Be ready. 5 seconds. Start. The court deprecated the casual and callous manner in which the disciplinary authorities had acted in conducting an inquiry into grave allegations of corruption of such a magnitude, where hundreds of appointments were made by the appellant without following the due process of law. Stop. A direction was issued to the disciplinary authority to appoint an inquiry officer with the approval of the chief minister, who should be apprised of the outcome of the disciplinary proceedings. Stop. Aggrieved by the said judgment, the appellant filed the present special leave petition before this court. Stop. The court, wide order 9 July 2018, issued notice on whether the appellant should be continued on suspension and whether the disciplinary authority should report the matter to the chief minister. Stop. Pursuant to the impugned judgment, the state granted sanction wide office memo dated 11 October 2018 to reconduct the inquiry from the stage of the charge sheet. Stop. By a further order dated 31st October 2018, this court ordered stay of the operation of the office memo dated 11 October 2018. Stop. We have heard learned counsel for the parties and perused the record. Stop. The issue which arises for our consideration is whether the appointment letters issued to 521 candidates who were B.Ed degree holders for the post of assistant teachers was conducted de-horse the mandatory procedure prescribed by the rules. Stop. The counsel for the appellant submitted that the continued suspension of the appellant was not justified and that his client had made the appointments pursuant to an earlier order of the High Court and also instructions from higher authorities. Para. Reliance was placed on a letter dated 10th April 2003 addressed by the Secretary, Basic Education, Government of UP to all the Divisional Assistant Directors of Education, Basic, Uttar Pradesh, wherein it was directed that orders passed by the High Court in connection with appointment of teachers be complied by the district basic education officers. Stop. It was further submitted that while letter dated 18 April 2003, the appellant had requested the Director Basic Education Uttar Pradesh to issue directives for appointment of candidates to the post of assistant teachers in schools who held qualifications of B.Ed. Stop. By a further letter dated 21 April 2003, the appellant informed the Secretary, Basic Education, Government of Uttar Pradesh that there were posts of teachers lying vacant in district Gorakhpur and there was no provision for appointment of candidates holding qualifications of B.Ed to the post of assistant teachers. Stop. The appellant subsequently issued a notification dated 25th April 2003 stating that a decision was taken to issue appointment orders to candidates with B.Ed/LT pursuant to discussions with the Chief Minister and the Minister for Basic Education, Secretary, Basic Education, Government of Uttar Pradesh, held on 23rd April 2003. Stop. It is also mentioned that he was given directions that if the appointments were not made immediately, departmental proceedings would be initiated against him. Stop. Accordingly, the appellant made appointments to 521 posts of assistant teachers in basic schools during the period May to June 2003. Stop. It was further submitted that the appellant sought the advice of the Chief Standing Council for the state of Uttar Pradesh. Stop. The appellant addressed another letter dated 6 May 2003 to the Secretary, Basic Education Council, seeking instructions on whether the appellant of candidates holding higher qualifications of B.Ed could be made in accordance with the High Court orders / directives. Stop.